25 minutes past 6 on Capital FM. In case you're just making a switch, this is Daybreak Malawi coming to you live. You can participate in the program by commenting on the stories we've carried or any matter of public importance. Send your views to 0999 852 102, 0999 852 102. Your feedback is very important to us. In our social story this morning, child rights activists are pushing the government to revise laws that would control the number of children, particularly boys, who are sent to prison over consensual sexual acts. Debate has ensued on the subject following a case involving a 15-year-old boy who was charged with the offense of defilement. He allegedly had consensual sex with a 13-year-old girl, but was later arrested following a complaint lodged by the girl's parents. The boy is being represented in court by the Southern Africa Litigation Center, SALC, and the Center for Human Rights Education, Advice and Assistance, CHREAA. The two organizations are concerned by the number of children who have been sentenced to lengthy prison terms for consensual sexual acts and the use of criminal law to address matters of this nature. Currently, Section 138(1) of the Penal Code criminalizes both abusive acts against children as well as non-exploitative consensual sexual conduct between adolescents. There are concerns that the law serves the purpose of protecting girls only, while boys of the same age are sent to jail on defilement charges despite consensual sexual acts. Leon Matanda, a youth and child rights activist, holds the view that the country should quickly make a decision on age of consent as cases of sexual activities continue to escalate among children.
Strongly, I feel that as a country is dragged feet in terms of making a decision about what age should be appropriate for boy and the girl to engage themselves in casual sex. We have by now seen that there's the escalating statistics in terms of sex activities amongst the children, exposure to materials and everything. But what indeed has been observed, it is the boy child who is condemned to be in conflict with the law. But we have come to a point where I think we need to decide what is the age where a child would have consensual sex with a girl child. We've really tried to fit in resolving that issue.
So how do you think that as a country we can move forward on the subject, as you're saying that we've dragged feet in terms of defining which age can be consensual for both parties?
We could look at what other countries have done, like South Africa. They have resolved this issue. I think they resolved this issue maybe 3-4 years ago. Perhaps still we should have looked at other countries who have done the same. I'm not sure about which other countries are in the SADC region, because we've been following closely about the progress in South Africa, because the network that is dealing with children's rights in the SADC region, called CHREAA, is based in South Africa. So when we were discussing this issue at some point, it emerged that South Africa had resolved it, and that's why it exercised my mind to say, why can we not emulate the speed with which South Africa have done? So maybe as a country moving forward, we should have looked at what South Africa has done, and if at all the social factors are the same, would have just as well looked at them and then think in terms of which is the appropriate age for kids to have consensual sex. South Africa is almost close to us. We have the same challenges in terms of social factors. So I think it is worth it to emulate what South Africa has done.
Leon Matanda, a youth and child rights activist. On his part, Executive Director of the Center for Youth and Children Affairs, Desmond Mhango, tells Daybreak Malawi's Chinsisi Moyo that children should not be given custodial sentence over such matters.
Such kind of laws are not compatible with the fundamental principles of non-discrimination, and also in appreciation of the fact that children will remain children regardless of gender or sex. They are subject to make mistakes in life. Because the same laws, if we refer to the Child Care Protection and Justice Act, does perceive that no child shall be guilty of any criminal offense. Children instead will only be liable for the mistakes. So which means regardless the kind of offense that a child commits, that child must be liable for the mistake and not the criminal offense. In that case, there should be nothing like giving custodial sentences for children. Moreover, the same law does not allow any child, regardless the gender, to be imprisoned. No child is supposed to be pronounced as guilty upon a finding, and it is a finding. It is not a judgment. It is a finding where a child must accept liability for the mistake. I'm surprised how this criminal justice system are able to conclude sending boys to prison because they have defiled a girl child. We should look at this law, the law of defilement. What it entails is that somebody who is an adult is having a sexual relationship with a minor, so to say, a girl child. So the key principle law in this case is the penal code, which must be revised.
What is your role as CHREAA in regards to such issues, as it has been brought to light that some children are charged with the offense of defilement and are imprisoned over the subject?
When these cases occur, CSOs take up the matter with authorities. But from my experience, there's a lot of resistance, especially from the police service, who don't really see this being valuable. So normally they put the boy child on trial. But within the police service, there are child protection police officers and child police investigators. There are also child police prosecutors. What it means that these are specialized designations within the community service department in the police, and that any trial of a case of a child is supposed to be in the child justice code. Therefore, these officers have all the knowledge about trial of children or those who are still to be tried under the child justice code. So where these mistakes are made, I don't understand them, because they are supposed to comply with the law, which says a child cannot be tried any other adult case or any other code other than in the child justice code. Even where the child is a charge alongside an adult, the child must be separated. So these are very surprising matters, to see happening. As regards our affairs, I think we need to do more in terms of raising awareness. We need to advocate a lot to change the law.
Desmond Muhango, Executive Director of the Center for Youth and Children Affairs.